Come on, counselor. Give me your legal opinion. This is a first year law student question.
I believe they would, more than likely. I think that would be a matter.
What would be the issues that would arise? I just want to understand how you think.
Well, ambiguity means that the words that are used are susceptible to two or more different definitions. So I don't know whether that's 50%.
Why do you go, I'm not suggesting you're wrong, but why do you go through that exercise? Why do you want to spend hours agonizing and debating how many lawyers can dance on the head of a pen to try to decide whether it's ambiguous? Why don't you just go look at the statute and also go to the secondary sources?
Okay, did you just see that? Because I need a second. That was Senator John Kennedy of Louisiana. And if you don't know who this man is yet, you're about to find out. What you just watched is exactly why people either love him or are absolutely terrified to sit across from him in that chamber. I've watched a lot of these confirmation hearings. A lot. And most of the time it's the same song and dance. Politicians grandstand, nominees dodge, everybody goes home, nothing meaningful gets said. But Kennedy doesn't play that game. He comes in with real questions that actually test whether the person sitting across from him deserves the job. And that snippet, that's just the appetizer. We're about to watch the full exchange, and I'm going to break it all down. The law, the logic, the moments where Kennedy completely cornered this nominee, and my honest take on what this says about who belongs on the federal bench. If you're new here, welcome. Hit subscribe because this is exactly the kind of content we do. And if you've been here a while, drop a comment right now. Tell me your first impression from that clip. Did Kennedy impress you? Was the nominee solid? All right, let's watch the whole thing. It only gets better.
Thank you, Mr. Chairman. Mr. Coleman, have you ever been to Manhattan?
Manhattan, Kansas?
No, sir, Manhattan, New York.
I have not.
Okay. Are you familiar with, maybe you've seen it in the movie, 3rd Avenue, Midtown?
Only by reputation.
Okay. Well, it's a major east or north-south traffic corridor. Very busy, a lot of traffic. I don't know if you saw the news yesterday, but about 200 protesters in New York sat down in the middle of 3rd Avenue. Completely blocked traffic. They were wearing T-shirts that said, "No war, no ice, free Palestine." Completely shut everything down for about an hour. Police had to come in. They arrested some of them. This is New York. Nothing will probably happen to them. But the point is it blocked traffic severely. Let's suppose a medical transportation service was trying to get a heart to a transplant patient at a hospital nearby. And obviously the traffic jam delayed him and the patient died. You with me?
Yes, Senator.
All right, does the patient's family have a cause of action against the protesters or the leader of the protest?
In any hypothetical, I would hesitate to completely prejudge the situation without knowing all of the facts.
Come on, counselor. Give me your legal opinion. This is a first year law student question.
I believe they would, more than likely. I think that would be a matter.
What would be the issues that would arise? I just want to understand how you think.
Sure. I think that would be.
If you're defending the leader of the protest, what's the first thing you're going to say?
If I'm defending the leader of the protest?
Yeah.
I would probably argue about causation and foreseeability. I mean, that would be really a state law negligence.
What do you mean causation?
Well, for any negligence claim, one of the elements is you have a duty to somebody. Did you breach that duty? Did you cause them an injury? And part of the duty causation calculus is how foreseeable that injury was.
What's the difference between legal causation and proximate cause?
So
cause in fact and proximate cause.
Yeah. So cause in fact is the specific cause of death or injury rather. And in this case, it would probably be whatever heart ailment this poor person that you've described had would probably be the cause in fact of his death. But proximate cause does not always have to be the cause in fact, and there can be multiple causes So a proximate cause is, but for this thing happening, this injury may not have occurred.
Okay.
And
Got it, good. Judge Powell, you said you're a textualist.
Yes, sir.
What does that mean?
It means you follow the words of the text of the statute.
Okay. What if the text of the statute's not clear? What do you do?
Well, one of the approaches that I do use is I want to look at the language in context of the statute as a whole and try to harmonize the language. I may go to dictionaries to help me find definitions of words.
Well, how ambiguous does the statute have to be before you're going to look to secondary sources?
Well, ambiguity means the language is subject to two or more interpretations. And so if there's
Reasonable interpretation.
Correct.
Well, I mean, does it have to be 50% ambiguous or 52% or 51%?
Well, I'm not sure how to apply the 51. To me, ambiguity
That's what
is
I'm asking you, is how you apply it.
Well, ambiguity means that the words that are used are susceptible to two or more different definitions. So I don't know whether that's 50%.
Why do you go, I'm not suggesting you're wrong, but why do you go through that exercise? Why do you want to spend hours agonizing and debating how many lawyers can dance on the head of a pin to try to decide whether it's ambiguous? Why don't you just go look at the statute and also go to the secondary sources?
Well, that's what I do, Senator.
But you only go if it's ambiguous.
Well, because the plain words of the words, the plain meaning of the words in front of you are what guide you. And you apply the common understanding
I guess what
of the
I'm
words.
asking you is, Your Honor, why? Don't you want to look to the problem that the legislature was trying to solve? Why do you want to be a slave to the plain words that reasonable people can disagree over? Why don't you just start with, I've got a statute, let me see what problem the legislature was trying to solve in interpreting the statute.
I have done that, Senator, and I don't disagree with that approach,
But you said you were a textualist. You don't even get to that approach unless the words are ambiguous.
correct. I agree with that. And
I know. So which is it?
well, you look at,
Are you always a slave to the words and the debate about plain meaning, or do you step back and go, plain meaning or not, I want to look at the problem the legislature was trying to solve? Which is it?
well, Senator, the best way to understand what the legislature
Yeah, but
intended.
first, our chairman's a great guy. He's like awesome. He's going to cut me off anyway. Tell me which one you use.
Senator, as I'm trying to say, when you're trying to discern the legislative intent, you first look at the words the legislature itself used, and
Yeah,
you apply
okay.
the
And let's
common,
suppose
ordinary
they're
meaning.
plain. They're plain to you.
I'm sorry, what?
Let's suppose the words are clear.
Okay. And then
Why you would stop there, right?
you apply the words, yes.
Okay. Why? Why don't you go, well, I want to get this right. So let me adopt a belt and suspenders approach, even though the words are plain. Let me delve into the legislative history and try to understand what problem the legislature is trying to solve. Why not do that?
Because the language tells you what it is they're trying to
Where's it
do and what
written?
it is
You
they want to
can't
solve.
go further than the language of the statute.
Well, again, Senator, if there's some doubt when you look at the
Even if
words in
there's no doubt.
context,
Not a doubt in your mind.
that's why because you're carrying out the will of the people. It's the will of the people that's
So
expressed in the pages.
you're trying to apply a statute passed by the legislature.
Correct.
Okay. Can I ask one more? Tell me how to say your name. Your last name, sir?
It's Mativi, Senator.
Mr. Mativi. I'm 17 and I go to work for McDonald's. I go to apply for a job and I'm wearing a burqa. And the McDonald's manager says, I really want to hire you, but we don't allow religious symbols at my restaurant or at our restaurants. What does the law say about that?
The law prohibits the application of a religious test applied by the government, right, not by private employers. So I would say that's the basis
Oh,
of.
you sure about that?
Well, it depends on whether, I mean, there's other factors, right?
Let me just ask you, can McDonald's say, we have a policy against religious symbols and you can't wear a burqa? Who's going to win, McDonald's or the person wearing the burqa?
Honestly, Senator, I'm not sure who would win in that situation. I'd need to know more
I
facts.
appreciate your honesty. Thank you. Thanks for your indulgence, Mr. Chairman.
Anything for you, Senator.
I especially appreciated your commentary. I listened carefully, Eric, and you're right about courage. It's easy to play to the crowds, but when the going gets tough and you got to follow the law, and it's not going to be popular, that's what the rule of law is all about.
That's right. That's right. Thank you.
All right, now you've seen the whole thing, and I have thoughts. Senator John Kennedy is one of the sharpest legal minds sitting in that Senate chamber right now, and that exchange just proved it. And I say that as someone who genuinely cares about the quality of people we put on the federal bench. This isn't about politics for me. It's about competence. It's about whether the person in that chair is ready for the weight of the robe. On the protest hypothetical, Kennedy opens with this New York protest scenario. 200 people block 3rd Avenue. A heart meant for a transplant patient gets delayed. The patient dies. Does the family have a cause of action? That is, as Kennedy himself said, a first-year law school question. And the nominee, a man being considered for a federal judgeship, hemmed and hawed before he even got to the answer. Kennedy had to drag the legal reasoning out of him. To his credit, once he got going, the breakdown of cause in fact versus proximate cause was reasonable. But the hesitation, the "I'd need more facts" response on a textbook negligence question, that should give all of us pause. Federal judges don't get the luxury of stalling. Kennedy knew exactly what he was doing. He wasn't really asking about protesters. He was asking, can you think on your feet? And the answer was, barely. On textualism. This is where it gets interesting, and honestly the part most people probably glossed over. Mative calls himself a textualist. Kennedy doesn't just accept the label, he interrogates it. He asks, why do you put yourself through the whole exercise of deciding whether something is ambiguous enough before looking at secondary sources? Why not just look at the words and what the legislature was trying to solve from the start? And Kennedy had a genuine point. Strict textualism taken too far can become a kind of intellectual rigidity where you're so committed to the words that you won't even use legislative history as a basic check. Kennedy was pushing back on the dogma of it. Now, Mative's defense wasn't wrong. The argument that plain words represent the will of the people is a serious legal position. But the way he struggled to articulate why he holds it, the way Kennedy had to pull it out of him piece by piece, that's the issue. If you're going to wear a judicial philosophy like a badge, you need to be able to defend it under pressure. That's the job. On the burqa question, Kennedy closes with the McDonald's hypothetical. 17-year-old walks in wearing a burqa. Manager says no religious symbols. She doesn't get the job. Who wins? It's a deceptively simple question. A lot of people's instinct is to say the Constitution protects religious expression. But the Constitution protects you from the government, not private employers. Title VII is what covers you there, and it's more nuanced. Reasonable accommodation requirements, undue hardship defenses. It's not a slam dunk either way. Mative said honestly, I'm not sure who would win. And Kennedy praised him for it. And I think that was the right call, because a judge who pretends every question has an easy answer is a dangerous judge. Intellectual honesty on a hard question is exactly what you want on the bench. But here's the thing. That moment only landed because Kennedy earned it. He'd spent the whole exchange stress testing this man, and when the nominee finally just said, I don't know, it felt real. Kennedy recognized it, and so did I. Overall, Kennedy came in prepared. He used real-world scenarios to test practical legal reasoning. He challenged a stated judicial philosophy not to embarrass anyone but to find out if the nominee actually owns it or just wears it. And he closed with a question designed to reward honesty over confident-sounding bluffing. That is how confirmation hearings are supposed to work. Most senators read pre-written questions off a sheet. Kennedy was thinking, listening, and following up in real time. Whether you agree with his politics or not, that is what good oversight looks like. The rule of law matters. The people we put in charge of interpreting it matter even more. And Senator Kennedy clearly understands that. All right, that's my take. Drop yours in the comments. Did Kennedy impress you? Did the nominee hold his own? If you want more breakdowns like this, make sure you're subscribed. See you in the next one.